Heard him say the man wasn't made to fly. And when he wanted to go to the moon, he said he wouldn't make it past the sky. And with all odds against him, he said he never reached his goal. He said he didn't have the strength to travel that long road. But I had a dream. I had a dream. I had a dream that I made history. I had a dream. I had a dream. I had a dream. Now the dream is real to me. Heard him say that the mountain couldn't be climbed. And whenever there's an underdog, you count them out every time. Yeah. Somebody said, oh, would never end. In the crunch of the game, they said there's no way that team could win. But I had a dream. I had a dream. I had a dream. That I made history. I had a dream. Yeah. I had a dream. I had a dream. Now the dream is real to me. Yeah. When the battle seems lost, when the strength is gone, just know that God is there to carry you. Just believe in the power of love. I had a dream. I had a dream. I had a dream. That I made history. I had a dream. I had a dream. I had a dream. Now the dream is real to me. I had a dream. I had a dream. When I was asleep, I had a dream. It would be real to me. That I made history. I had a dream. I had a dream. I had a dream. I had a dream. Now the dream is real to me. It's real.
What up, everybody? Glad to see y'all in here. Hey, chat. Hey, Caramel. Hey, Nakia. Hey, Miss Dixon. Hey, Love Yourself. Hey, Rel. Hey, Ashley. Hey, George Girl. Hey, Ern. Hey, EJ. Hey, Miss Fernanda. Who I miss? Hey, Elizabeth. Hey, Marcia. Hey, Lavero. Hey, Mama Mary. Toy. My sis Toy. Hey, Ashley. Look, let's get it going. We're going to rock out for real. Let's do it.
They keep coming, watch us in. They gotta leave us alone. Away from the door. Say what you gonna do now? Hope you're ready, cause I'm really about to put it down. I don't ever disrespect you. Tomorrow, but tonight I was playing you. Yes, I'm trying to make it last. But I'm so good, I'ma be on the best. But I just sit down, let me know. Tell you just get low. Back away from the door, just keep reminding me from the line, flying here. She got me starting and I ain't no stopping here. So they're popping here, they keep coming, watch us in. They gotta leave us alone. Back away from the door, I want it all. Gotta let me get it on. From the bed to the floor, against the wall. I'ma get it soft, turn around and hit it all. And maybe tell them it's on. Back away from the door.
Yeah. What up, everybody? Hey. Hey. All right, we're gonna get it in real quick. This early live is not the going live. The going live will be back at 8:30 tonight. But this live, I got to bring it to you because something special happened. Excuse me, everybody, for chewing. But let me handle some business real quick. 115 cold for. I love to hear that. That's the sound of having a job. Hey, Carmel. But this live is not the going live. And I'm gonna go here. I heard somebody say every time Dana J go live, they all gonna go live, huh? Well, I'm glad. And I ain't gonna brag, but with the firm on my side, we always gonna be good. Y'all don't have the sustained power I got. Picture that. And tonight, Kevin got company. Tobolski, you on the hot seat. So it is what it is. But right now, we talking about Robert Sylvester Kelly. So I ain't gonna prolong it. Let's get down to it. Look to the screen, y'all. And we're gonna go in like this. And see, and this is what they mad about. Because nobody have what the firm have. It's not just one person. We're a team. So nobody have what the firm have. And like I said, if you're looking for the drama this early, nah, you got to come back at 8:30. Excuse me, 8:30. I'm digging in that tail. I ain't even going to cuss on this live. At 8:30, I'm going to dig in that you know what. Feeling good today. Got my Twizzlers in hand. I'm really kind of upset because these the no sugar Twizzlers. Ugh. But hey, Twizzlers, they my favorite. So let's go ahead. Mike Leonard, electronic filing. Honorable A&M Donnelly, United States District Court, Eastern District of New York, 225 Cadman Plaza, East Brooklyn, New York, 11201. United States versus Robert Kelly. Dear Judge Donnelly, if you got to go get something to drink, go ahead and do it right now. I'm going to give you time. You got 40 seconds. $30 seconds. $20 seconds. 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. Let's go. Dear Judge Donnelly, we respectfully submit this letter as the response on behalf of Mr. Kelly in opposition to the government's motion for an anonymous jury and for certain restrictions on Mr. Kelly's Voir rights. As further set forth below, the government's motion should be denied. the government's request for an anonymous jury. The impaneling of the anonymous jury presents the possibility of unfair prejudice to the defendant and the danger of encroaching on the presumption of innocence. United States versus Ashburn 2014 WL, that's case law. Thus the impanelment of an anonymous jury is a drastic measure and is one that should be taken only in limited circumstances. United States versus Mustafa, that's a case law. And United States versus Thomas, that's another case law. In the present case, the circumstances presented do not support the imposition of such a drastic measure. Indeed, in Mustafa Supra, the court denied the government's motion to impanel an anonymous jury and to impose certain protective measures for the jurors, even though the charges in that case were, well, that's supposed to be far more serious than those presented in the present case. In that case, the defendant was charged with acts involving material support of terrorists and terrorist organizations, as well as hostage taking. As the starting point for its analysis, the Mustafa court first noted that the principle that a shield of innocence surrounds a defendant extends back to ancient times, citing Coffin versus United States. Thus, the Mustafa court emphasized that any practice that may impact the shield of innocence requires close scrutiny and light of reason, principle, and common sense. Hold on, I'm elaborate on that. Hold on. Oh, I got blue in those. Wash your hands. Wash your hands. All right. The most beautiful thing in the world to be able to use some soap and water. Ooh, they say cleanliness is next to godliness. All right, so basically, that first paragraph breaks down the fact that Rob is not holding nobody hostage. But for months, y'all heard the federal government say R. Kelly has hostages and has a sex cult and has sex slaves. So now that that's going on, you got to look at the fact that where's the hostages? Where's the sex cult? Where's the sex slaves? Oh, I forgot. All that's been thrown out the window now that R. Kelly has been picked up. And for the people that's watching my joint, thank you so much for giving me the view. I appreciate you. You know what I mean? And no matter who you are, come and get this work. This knowledge will set you free. Also, I only require that if you're going to record anything that's being said over here, if you're going to watch it publicly, I only require that you acknowledge that it comes from the original content, Mr. No Content himself. Until then, thank you so much. So basically, what the defense is saying that everything the federal government has been posting and presenting has been a lie, especially concerning the sex slaves. They just showed you and they gave you case law showing that this only is dealing with terrorists and terroristic situations, as well as hostage taking. Have a question. When has R. Kelly ever become a terrorist? I'll wait. When have R. Kelly ever became a hostage holder? I'll wait. When have R. Kelly ever became a handler? I'll wait. If you can say that he is any of those, I guess all of our relationships, we were the same. And I'll tell you why. In a relationship, there's rules that both of y'all abide by. When somebody break the rules, y'all have arguments, don't y'all? Y'all have disagreements, don't y'all? Some people have fights. Some people drag it out and just beat the damn shit out of the other person. Well, at the end of the day, you call a family, you get mad, your family tell you, don't be with him, don't be with her. But then y'all back together by 12 midnight. And then when people be like, why? Girl, I love him. Man, you don't understand, boy. She the truth, man. I love her, bro. So with all that being said, it's called relationship woes. And if you can deem R. Kelly as a hostage taker, as a relationship handler, then shit, we all won. If you're going to hold a man according to what's being dictated in their bedroom, then Lord, I guess we all a problem. Because I never knew anybody. And I'm going to say this, I could be wrong because I don't know everybody, but I don't know nobody nowadays who like average sex. Who likes average sex? What woman just like the same routine over and over and over and that's it? I mean, I know some guys who like their back scratched. I know some guys who like to get bit. I know some females who like to get their hair pulled. Hell, I know some females who like to be put in handcuffs and put in restraints. But when did that become a crime? When did that ever become a crime? Well, let's continue. In denying the government's motion, the Mustafa court held that the choir serious charges. I'm sorry, not questions. The Mustafa court held that the choir serious charges against the defendant were not in and of themselves an insufficient basis upon which to grant an anonymous jury. Moreover, the Mustafa court rejected the government's argument that the fact the case might garner significant media attention was a sufficient basis to impanel an anonymous jury because that occurred in any number of cases tried in the Southern District each year. Finally, the Mustafa court held that the government had failed to appropriately establish that this defendant or this case presents a situation in which a jury faces real or threatened violence. Accordingly, in denying the government's motion, the Mustafa court credited that the defendant's argument that the impanelment of an anonymous jury will poison the atmosphere of the case and serve to bolster the government's case by creating the impression that the defendant is dangerous and guilty, and that the jurors themselves are likely targets. I know I have at least 60 people from New York watching my live. And I'm going to say this. I know at least 30 of them read the motions. And I'm going to say this. Robert Sylvester Kelly do not know a DJ Tyson. Robert Sylvester Kelly do not know a Daboski gun. Robert Sylvester Kelly do not know a Hollywood Next. Robert Sylvester Kelly do not know any of their followers. So Robert Sylvester Kelly should not be held accountable for what they have done on YouTube. I need you to look within yourself. And I'm speaking to jurors. I need you to look within yourself and come to the fact and say, if this was me or if this was a family member of mine on trial, would I want them to be prosecuted for something that other people are doing to gain some type of fame or attention that the person that's on trial do not even know? Let's finish. The court's decision in the Mustafa is on all fours. All fours mean all four legs to bring a lawsuit. That's what it means. The court decision in Mustafa is on all fours, and you need 4 legs to bring a lawsuit. With the circumstances presented in Mr. Kelly's case, first, clearly, the racketeering and related charges pending against Mr. Kelly are far less serious than the terrorist and kidnapping charges that the defendant faced in Mustafa. Totally agree. Likewise, just as in Mustafa, the fact that this case may attract significant media attention is nothing out of the ordinary. More importantly, that media attention does not serve to establish in any way whatsoever that this defendant, Mr. Kelly, or this case will subject to jurors to any sort of real or threatened violence. And that's the Mustafa Supra at 338. Indeed, that this case will attract media attention is wholly irrelevant to that issue. Furthermore, just as in Mustafa, the government has failed to legitimately establish that Mr. Kelly is in any threat to the judicial process, including by way of witness tampering. I'm going to read it again. Furthermore, just in Mustafa, the government has failed to legitimately establish that Mr. Kelly is in any threat to the judicial process, including by way of witness tampering. Once again, Robert Sylvester Kelly do not know a DJ Tyson. Robert Sylvester Kelly do not know a Dabowski gun. Robert Sylvester Kelly do not know a Hollywood Next. So with that being said, the actions that DJ Tyson took of badgering alleged victims, because I call them accusers, but alleged victims, was not under no circumstantial dictatorship of Mr. Robert Sylvester Kelly. Actually, Robert Sylvester Kelly did not know that was going on until he was notified. Also, the blowing up of the car was not orchestrated by Robert Sylvester Kelly. I believe that was the actions of a man who have a rap sheet of being an arsonist and blowing up cars. All you got to do is stay tuned and drop back in here at 8:30. I'll give you the whole synopsis of what I believe. Just like he gave a synopsis of what he believed about me, and he spreaded it, I'm going to give it what I believe about him. Let's get back to it. The history of the numerous currently pending cases against Mr. Kelly make this very point, as has been pointed out to this court in several prior motions. The judge in the currently pending Illinois state court case allowed Mr. Kelly to be free on bond. Mr. Kelly remained on bond as a result of that order for months, and prior to being taken into custody for that currently pending case in the Northern District of Illinois. There has never been any contention by anyone, let alone any evidence brought forward by way of a proffer or otherwise, that Mr. Kelly ever did anything to attempt to impede the judicial process in the pending Illinois state court case after being released on bond. In addition, during the pendency of the present case and the Northern District of Illinois case, Mr. Kelly has similarly, not attempted to do anything to interfere with the judicial process, including contacting or attempting to improperly contact or influence witnesses, either by himself or through others. In fact, the government in the present case, as well as in the NDIL case, allowed and did not object to Mr. Kelly having in-person visits, email communications, and correspondence with one of the alleged victims in the present case while he has been in custody in the NDIL. Perhaps the government's motivation was that Mr. Kelly would do something, anything, to allow it to claim that Mr. Kelly had attempted to influence the judicial process in the present case. In any event, Mr. Kelly never did. Similarly, despite the government's repeated assertions to this court that Mr. Kelly has both financial resources and a purported network of supporters and enablers outside the walls of the Chicago MCC and across the country. Tellingly, there has never been any proof presented by the government in this case or in NDIL case that those unidentified persons has ever made any attempts to improperly influence the judicial process in this present case. Finally, if Mr. Kelly continues to remain in custody during the trial of this case, he will be in custody in the Eastern District. He will have no ability whatsoever to attempt to improperly influence the judicial process in this case. For all of those reasons, the government's motion to impanel an anonymous jury should be denied. And then it goes to the government's proposed restrictions on Mr. Kelly via dire rights. Oh, man. Let's go. This court shall also reject the government's request to limit Mr. Kelly's attorney's ability to conduct a fair, thorough, and meaningful voir dire in this case. To that end, the government requests that potential jurors' names, specific residential addresses, and the identity of their employers remain unknown and secret. Voir dire is one of the most critical phases of the trial. To unduly limit it in the manner suggested by the government will fundamentally deny Mr. Kelly and his counsel to the opportunity to fully and meaningfully probe the potential bias of the venue. And then they have a case law, United States versus Dinkins. Let's scroll down. It says, first, with respect to the names of the jurors, Mr. Kelly and his counsel agreed that those names need not be disclosed publicly or be made part of the record during the pendency of the case. I agree with that. So, scroll down. However, at a minimum, the names of the potential jurors must be made available to Mr. Kelly's counsel and the government. Mr. Kelly and his counsel are not requesting that those names be made available to Mr. Kelly as well. Even though there is no legitimate reason not to do so, Mr. Kelly and his counsel will live with such a limitation. And that's United States versus Napout. Let's scroll through that. That's United States versus Napout right there. Then it says to keep the names from the attorneys for the parties would not only run afoul of the Second Circuit's precedent and nap out, it also completely ignores the reality of the modern world and the reality of jury selection in the modern world. Mr. Kelly's counsel is not asking for the names of the potential jurors in order to make guesses and rely upon biases and prejudices about jurors' nationality and ethnicity. We now live in a digital world. The amount of information readily and publicly available, including on social media and or readily available through extraordinarily basic Google searches, run by even such technology novices as Mr. Kelly's defense counsel, provides tremendous insight to the thought process and the potential biases of potential jurors. Not to mention insight into what they have read, heard, or posted about Mr. Kelly or this case. Without the names of the potential jurors, it is impossible to engage in such basic jury selection activities. Indeed, it would be tantamount to malpractice or in any criminal case, ineffective assistance. For an attorney to fail or refuse to engage in the above referenced simple steps to research potential jurors, indeed, those simple steps also serve as a check on the veracity of the responses provided by potential jurors or jury questionnaires and doing voir dire. Without the names of potential jurors, however, none of that is possible. And then it has a case law, States versus Tiemann. That's all case law. All case law. At the time of the trial, though the defense made a strategic choice not to look for social media information, none of the 7 lawyers or the 2 jury consultants on the defense team performed the rudimentary Googling that located this set of Facebook and Twitter posts. Not during the 2 months they were in possession of the entire set of jury questionnaires with the jurors, names on them, not during the 4 to 5 days before trial when they knew the exact order in which the members of the jury panel would be questioned and seated as jurors, not during the 2 days of the jury selection, and not overnight after the 12 jurors and 2 alternatives have been picked and instructed to return the next morning to be sworn in. Wow. And they use Roger Stone. Oh my God. Okay, let me read this. Recently, the trial court in the Roger Stone federal criminal prosecution in the District of Columbia recognized the importance, even basicness of social media research during the jury selection process. So basically, they going as far as showing how social media played a part in all of this. And they showed right here, this is a social media account as well as a case law. For all those reasons, the government's request to deny the names of the potential jurors to the attorneys for the party should be denied. Wow. The government's request that Mr. Kelly and his counsel be denied the names of the actual employers for whom potential jurors work should similarly be denied. Again, Mr. Kelly and his counsel agree that such information can be kept secret to the public during the pendency of the trial and even be denied to Mr. Kelly. However, there's no reason that Mr. Kelly counsel and counsel for the government should be denied that information. Such a limitation ignores the reality that companies have corporate cultures that may influence the thought process and bias of potential jurors. There may be a big difference in the actual or potential biases of jurors who choose to work for a company that supports Black Lives Matter versus a juror who chooses to work for a company that actively supports such a movement, regardless of how that juror self-reports or does not report. His biases on a juror questionnaire or doing voir dire. Moreover, armed with acknowledgement of a potential juror's actual company affiliation. Jury research can be appropriately conducted on publicly available information. For example, knowing that hypothetical potential juror Sarah Jones works for the hypothetical Acme company goes a long way towards narrowing down whether certain social media and other posts were made by the Sarah Jones, who is part of the vineyard from thousands of other individuals known as Sarah Jones. In addition, the Sarah Jones may be affiliated with publicly available posts tied to or disseminated by the Acme company, ranging from posts reflecting opposition to Mr. Kelly to posts that reflect the potential for the acceptance of bias by the potential juror, such as funding for the rights of those subjected to alleged sexual abuse or opposition to such things as the Black Lives Matter movement. Whew. Then it says, finally, the government's request that Mr. Kelly and his counsel be denied the actual residential addresses. We don't need to go into that because nobody need to know that. At a minimum, this court should require the disclosure of the specific particular neighborhood in which each potential juror resides. If not, that individual specific address. United States versus Wong is the case law provided. Then you come down. Then it said, then it just got all the case laws. Wherefore, Mr. Kelly, by and through his counsel of record, wherefore, Mr. Kelly, by and through his counsel of record, respectfully requests that this deny the government's motion for the impaneling of an anonymous jury. In the event that this court grants that motion, Mr. Kelly respectfully requests that this court provide all counsel with juror information consistent with the positions articulated above. Sincerely, Michael I. Leonard. CC all counsel of record. So, with that being said, and with that going on, that puts the government in a place where they're going to have to tell who did what. So the next motion might have the names of the people who's attacking the alleged victims. I don't know. I said it might. But I love Mike Leonard's motion because he's not playing with the federal government. And I know people say the federal government got a 98.6% conviction rate. Well, that's because people plea out. That's because people don't plea out. So if you really want to look for people that's doing dirt, just look on social media. And I'm quite sure I got both parties looking at my social media. And I'll say this. With both parties, the defense and the prosecution, looking at my social media, I don't care. I can honestly say this. I got woken out my sleep today with a lie. And I've been pissed off ever since. It's one thing to just not like me. That's fine. I don't give a fuck. It's another thing to make allegations so drastic that it's going to come back on you. So the word on the street is, and I'm going to show y'all just how dumb a lot of these followers are. What's up, Bill? Word on the street is the U.S. Marshals are looking for Dana J. The U.S. Marshals are looking for Dantes Jackson. I wonder if that's true. But then again, I don't have to wonder. Because if y'all can remember, they came and got me from here. And they questioned me. So now that I took 50,000, and then from 50,000, I suppose they had took 330,000. From 330,000, I suppose they had took 9,000. And from 9,000 now is 2,200. What is it? $2,098 or $298,000, something like that. And I supposed to be questioning about it. Do I look like I'm bothered? Do I look like I'm phased? But since y'all want to put them lies out there, at first I was going to destroy Tyson again tonight. But then I got an email. A very disrespectful email. So I might just let Bedbug rest for tonight. But one of his homies is in trouble. Because now, once again, I cannot lie to the people. I got to present facts. If I don't, it'll make me look like a liar. So I'm going to present some facts about one of his DHD folks. And I'm going to say this before I announce who the victim is tonight. This name I'm about to say is not the victim. But I'm going to say this, Trent. Here's your time to get away from the bullshit. Run. Far away from the fuckery that you've been attached to. I don't care what you investigating. I don't care who you investigating. I don't care who you covering up for, Trent. I'm one of the best to ever do it. I don't have to lie. I don't. And I'm telling you, I've been this monster for a while when it comes to my name, my brand, and me. I've been this monster for a while. So I will protect me and anybody around me at all costs. I'm willing to take that forever, eternal ride to protect the ones that I love around me. So here's advice. Run, Trent. I seen when you had your mom on there and you wanted her to vouch for you. But you remember you put a post up about my mother of why she should have swallowed me? I'm willing to ignore all that, brother. Especially after talking to Well, I ain't gonna go that far. But especially after talking to the person that we supposed to be advocating for. I get what he told me. I get what the inner circle said. Or should I say what the brotherhood said? I get it. So Trent, I'm begging you. Detach yourself from the bullshit. If you're going to do things on your own, do things on your own. But I'm going to respond to the one thing you said, brother. You said Dana J's supposed to be close. He's supposed to have raised Dana J or whatever. He's supposed to did this. He's supposed to did that. But he was not there. Let me refresh you. I had two successful rallies in Chicago and didn't ask for a dime. Didn't disrespect nobody. Let me refresh you, brother. When you see Rob going in and out of court, who do you see with him on majority of his joints? When it came to raising money for Robert, for the defense fund, who jumped out there and raised money? Who jumped out there and was a spokesman and didn't touch nothing? That's why I invite you to have your investigation. But what I also know is that a certain gentleman had the same investigation group up on his page too. I play dumb, but I'm not dumb by a long shot. And I don't forget anything. So no matter if it's a group effort or if it's a single effort, Trent, anytime you want the truth, ask me. I don't need to lie. Ask me. But if you working with Bryant Nick and anybody attached to him like Don Russell, it's the same mistake that was made in before. You can't rock with Bryant Nick and Don Russell don't be in the forefront somewhere. They are boys. That's just like, and I'm gonna go on record and say this. That's just like Rob working with Don Russell's mom and then kicking Don Russell to the side. You still working with Don Russell. And now I'm glad that Rob see that. So that's all I got to say about you. But Dubowski, you called in last night. You act like you wanted to squash some things and you act like you wanted to talk, and Bed Bug got mad and said, that nigga, why didn't he check Levi? Why didn't he check Bozo? Look, I see who's got the battery in y'all back. And that nigga ain't busting a grape in a fucking grape factory. So I was willing to let that go, Dubowski, until I got a email. Until I got an email. Now, you said you want to leave stuff out of it, right? You said, I don't want nobody saying something about my kids. But you said something about my kids in this video. I was willing to let all that go. Then you said something about somebody that I really care about. I was even really to overlook that. But one thing you said that scared me and pissed me off at the same time. Because until that video, I looked at you as a man. So now I got to show what I look at you as now. Because I'm all man. And I know you probably try to call in tonight. Nah, it ain't no more talking to you, bro. I got nothing else to say. 8:30. That's your day and time to be broken down, bro. I never seen another man. I'm lying. I did see one, a nigga that you tight with. But I never seen another real man get mad at somebody and then talk about another man's dick. I know a lot of y'all like, what the fuck he just say? Yeah. I'll see y'all at 8:30. Trust me. Today is your day of atonement. I ain't playing with you, bro. You got me fucked up. I'll holler at y'all at 8:30.